in the courthouse where time stood still. Generations pass on the hill, prosecutors come and go, defense attorneys putting on a show. Old district attorney thought she was tight, came in to visit her tonight. They said justice was blinded by her sins. As the trial spun, no one wins. Endless trial like a river flows. Truth and lies, nobody knows. Corruption, split tight as fights. In this endless trial, we pay the price.
Hey, yo, folks. We have a live feed through 11 Alive because, Law and Seaward, not, their stream haven't started yet. But this is live from within the courtroom. The first time since Wednesday afternoon, we actually have a live feed from the courtroom. Well, it's the seal, but it's better than what we have had so far. Oh, this is interesting. This is interesting. Let me put up a banner. Sorry, I'm speaking. I'm having a hard time doing two things at once. Multitasking isn't my forte. If I chew bubble gum and walk stairs at the same time, I forget to breathe. There. Okay. I will call this day 152 Groundhog Day, because day 152 has been occurring since Thursday. So Thursday, Friday, Monday, and finally, they are back in court with live feed. Now, 11 Alive does not have closed captions, and they have this weird noise in the background. And okay, Law and Seaward is on. So it's up to you guys. Do you want closed captions or not? Press 1 for closed captions. Press 2 for I don't care. And hello, Paralegal Liz, John Commune, Wendell Taylor, Christine Gladstone, Hugh Kerman, Gwendolyn, Just Jen, Chicken Poop, LaShawn, Snivels, Kristen Vasquez, Shani Graham, Neo Dark Matter, me, Studozo, Dokweni. I'm so sorry if I butchered your name. And let's see here, who else was here from the Reformed Convict was here an hour ago at least. Hope you are here now. Okay, it seems like you don't care about closed captions. Now, if you listen here, the static from 11 Alive might be an issue, because let's see if Law and Seaward has the same static. Yes, they have. Okay. So let's go with 11 Alive support. Somewhat smaller. Go subscribe to 11 Alive. Okay, now. Oh, Hugh Kerman said also talk about confirmation bias. People that need closed caption cannot vote as they don't know what you just said. Just a cute example. I did not think about that. All right. Then law and C word it is. Law and C word it is. All right. Rumors. Rumors are that at least two defendants have taken plea deals. Rumors. No confirmation whatsoever. But rumors are that the two Quays has taken plea deals. And for Mr. Nichols, it is 20 serving 7. Which might sound like a bad deal, but you have to remember, he's facing life. Taking a plea deal for 7 years, that minus time served, and he will be out in maybe 3.5 years. If he is convicted here, he won't be released until he is in his 70s, and so is for the other Quay. So don't judge them for taking deals, please. My one thing that I'm hoping for is that the plea deals involve not testifying. I think that is, for the rest of the defendant, that's the huge deal here. That the prosecution cannot force them to testify. But that is the only rumor I have had heard. The only rumor. And there are, now, I've seen other rumors, but I don't pay attention to them because there are some credible sources here. Thug Daily, for example, Kathy Russon, Mr. Byron, Sylvia. I mean, there are a few credible sources, and if they don't retweet it or bring it up, I'm not believing it. I do not believe it. John Commune says, in the end, the defendants have to do what's best for themselves. No judgment. Yeah. And I do agree with that. Because working together as a group during the trial, yeah, that has worked. With the Harvey rule and not undermining each other. But when it comes to the actual sentencing or plea deals, they have to do what they feel are best for themselves. And that should not go back to the attorneys, because ultimately it is the defendants who decide. Okay. Thank you so much for the support, John. Thank you so much. Now we are seeing movement in the courtroom, but that doesn't have to mean anything. Doug has tweeted that his client is not taking a deal. And I completely understand. I completely understand that Doug's client won't take a plea deal because the charges against him are, to my knowledge, his client is not charged with any of the murders, to my understanding. So, okay. I assume, this is also speculation, I assume that that is the answer from Mr. Steele as well. And Shannon is harder to predict. Here we go. There we...
Come to order.
Good afternoon. Everybody can be seated. All right.
First things first. Miss Sylvia and Mr. Byron, if you all could both please come up to the podium.
Come on. What is it now? First thing that happens is that Miss Sylvia and
Yes,
Mr. Byron.
please. Thank you.
Are they going to kick out Rule 22? I hope not.
All right, so for both of you, I am sorry to have to say this, but I am going to be entering in order modifying each of your Rule 22s. It has come to my attention and I have confirmed that each of you has been recording in the courtroom while I have not been on the bench, and that is a clear violation of Rule 22. And so you may record today's proceedings, but after today, if you want to record, you're going to have to do it from the media room. You may be in here in the courtroom as a spectator without any recording equipment, or you may be in the media room to record, but no more with your equipment in the courtroom because y'all have both recorded things that you're not supposed to be recording based on Rule 22. So I'll enter those orders today. Thank you. All right. It is my understanding that we have a plea to be tendered for Mr. Nichols. Is that right?
I will bring that.
All right.
Your Honor, may we approach?
Rule 22. But now plea deals have been entered. Okay. First of all, I do believe that, or at least I'm not sure about that thing, recording when she's not there. What does that mean? I'm not entirely sure. Well, if it is within the breaks, and Miss Sylvia has told the judge, I am snapping photos of the defendants. Has she recorded in breaks when Judge Whittaker might not have been in the courtroom? I don't know, but I don't believe that is against Rule 22. I do believe this is from Miss Love, because Miss Love have tried to throw out every piece of media from the very beginning. No one is allowed to record while the judge is not seated. I have to look closer into the Rule 22, but that might be what this judge has said on her Rule 22 approval. But I don't believe that is stated in the actual Rule 22. Oh, yeah, she recorded, yeah, when Love was throwing her tantrum on Wednesday. Yeah. Okay, but I do believe that you could spot the judge in the background when that happened. But, yeah. And hello over at Rumble. Hello, Slidey Pie. Hello, Hunter Wim. Good to see you here. Good to see you here. Yes, I'm streaming at Rumble as well, because you never know when you need a backup plan. A lot of channels get yeeted and demonetized and for odd reasons all the time on YouTube. Hence, I'm streaming on Rumble and X, Twitter as well. Now, those two, revenue is... I have no revenue from X. Maybe I will get it in the future. Over at Rumble, I get the occasional Rumble rant, but the main thing that keeps this channel running is here on YouTube. Okay. They asked to approach. Know what that means? Sidebar counter 318. This might be one of the last sidebar counters in this trial. I don't know what happens after plea deals are granted. If this means that the trial has to be a do-over. If she grants the plea deals for both ways, for example, pure speculation now, not facts, pure speculation, that after their plea deals are accepted, it has to be some kind of mistrial, because how do you explain to the jury this? Now, plea deals during the trial happens. It actually happens a lot. Not a majority of the times, but it does happen a lot. For instance, I believe in the Sarah Boone case, she was offered a plea deal after the jury was seated. And she didn't take it. But normally, it's just that defendant. What happens now in a RICO? I'm not sure. I honestly have no idea what will happen with the rest of the trial if they do a do-over. Reform Convict says they might mistrial and the state not retry the case, especially if Big Funny was to be re-elected. Yeah, but if only 2 take plea deals, what happens with the rest of them? And imagine the judge after 11 months saying to the jury, 2 people have pled guilty. You are not to disregard that to the others? No. Oh, hell no.
And Mr. Harvey, Ms. Westmoreland, and Mr. Garland, who's going to be taking the lead going through the plea? Okay. All right, Mr. Harvey, do either you or you, Ms. Hilton, need this plea of guilty and waiver of rights form back?
Okay. So, 3 plea deals. Half of them.
Thank you.
All right, Mr. Nichols and Mr. Harvey, whenever y'all are ready, you can come on up to the podium.
Mr. Harvey said he's signing the indictment.
Okay. Whenever y'all are ready.
Your Honor, I'd like my client to be present for this. He's a member of the public, and I would like him to observe this, and he has a right to be here.
Okay.
Thank you.
Can we get
Are you granting
Mr.
that?
Kendrick
Thank you.
out, please?
Okay, they only brought up...
Oh, wait, Your Honor, I'm sorry. Can we You have the, yeah, can I approach?
So 3 deals. 3 plea deals, it seems to be. Okay. Those are half of the defendants. Half of the defendants. Yeah, I had a big jump scare just moments before I was going live. StreamYard crashed. And it took a good minute and a half before I was back in. And with Doug up there, sidebar counter 319.
Okay. We are going to recess for just a minute, and I am sorry about that, but I'm going to have to ask everybody to step out for just a minute, and then we'll let y'all back in, okay?
Okay, this seems to have something to do with Mr. Weinstein's demand that his client be there. Now, I'm actually going to go back a few seconds.
We'll let y'all back in, okay?
Because somehow, there you go. My closed captions were back to black and white. All right. So, what has happened? Well, the first issue was that both Mr. Byron and Miss Sylvia were thrown out. Well, they are allowed to record today, but after today, they are no longer allowed to record in the courtroom. By Judge Whittaker's Rule 22, or she might have conditions in her approval of them being there that we don't know about. I haven't actually seen the actual order. I'm not sure why. But then again, she has forced this pool feed to, once she leaves, once they are doing sidebars, put it up to the seal. If she's leaving and they have a recess, point to the seal. So now with a second thought of this, it seems like this has been in the Judge Whittaker's orders when it comes to recordings in the courtroom. Judge was referring to Quay's 3 lawyers. No, but Harvey represents Nichols. Mr. Williams and Miss Abbasi is for one of the others, and then you have, what are their names now again? Brown? I want to say Brown. She only mentioned one deal. Okay, I stand corrected. Now, if it is Mr. Harvey's client, but I would understand that, because Mr. Harvey has been asking for his client to be severed for quite some time. De Williams is for Little Rod. Thank you. Nichols and his lawyer's name. He's one of the Quays. I'm so worked up, I'm forgetting basic facts here. Thank you, chat, for moving me in here. For moving me into the path. Derek. Nick, how are you doing tonight? I'm worked up. And coffee plus worked up. Yeah. So, okay. But that means rumors, at least before everything started, is that there were 2 plea deals for both quays. Thank you, Brenda. 1 quay is for Nichols. Yes, Quintavious Nichols. And then you have Stevens, Quintorius Stevens, if I remember the names correctly. If I don't, I am certain you guys in chat will remind me. Yes, reformed convict. Caffeine and YSL is like a drive-by happening. Yeah. As GD, my first and best moderator, says, don't forget to change from top messages to all messages on the live chat so that you don't miss out on all the fun. Kristen Vasquez. So the defendants aren't in the courtroom, just their attorneys. Well, the defendant for the plea deals are there, but Mr. Weinstein wanted his client in there as well to listen in on this. And I also understand why. Because this should not be secondhand information to Huey. Thank you. Another quay. Thank you, Brenda. I'm so worked up that I keep forgetting who's actually in here. Thank you guys for reminding me. Yeah, she didn't mention Mr. Matthews, who's the attorney for the other quay. That's correct. That's true. So, going back to what we discussed earlier, what happens with the rest of the trial if one person is out? And if it is Mr. Harvey's client, he has been asked to sever his client from this trial from day one, from before day one, and wasn't allowed to. Finding good. So breathe, Nick. We ain't John Chickens. All right. I will take this a bit slower. I will take. Yeah. So what happens if Mr. Nichols takes a plea deal and is gone? Well, if the trial continues, there has to be a jury instruction. And mid-trial plea deals, in my opinion, I'm not sure if this is the law in Georgia, but my opinion is that would be extremely prejudicial against the other defendants. They are co-defendants in this. So I don't know if there will be more trial, or if it is she takes the plea deal from 1 person or 2 persons, I'm not sure, and then declare a mistrial without prejudice, and they have to start over. Your first fan, how can they remedy that with the jury? It's highly prejudicial. Yeah, because it's one thing if she said Mr. Nichols is severed from this case, and so are the charges regarding Mr. Nichols. That's one thing. Saying Mr. Nichols had accepted a plea deal of guilt, that is way too prejudicial against the others, in my opinion. But we do know that from Mr. Weinstein that I will show you. He says, our client, Diamante Kendrick, has been wrongfully accused and incarcerated since May 2022. We continue to fight for his freedom so that he can be home to his family and support system that all love him very much. He appreciates all the love and support from the public whose words and deeds have helped sustain him during these many long months. Last edited my time 40 minutes ago. So yes, I would assume he will not take any plea deal. Oh, what happened? Oh, sorry. Let's get back to this one so we don't miss anything by mistake. Hey, Nutty Brunette. Oh, PayPal. I forgot. I have PayPal. Hasn't arrived yet, but I will accept even a virtual one. Yes, I do have a PayPal. If you want to support my channel, but not give 30% to YouTube, use PayPal. It is pinned on the top of the chat, and I will read the messages you post there as well. Just as long as you tell me in that message what your handle is on YouTube. Ooh. Ken's counseling couch. We need a compilation of all the things the jury was told to forget. Oh, God. Well, 1/3 of what Mr. Dennis testified to, and half of what Woody told the jury, and then a dozen more jury instructions. At least a dozen. Oh, there's more than a dozen. It must be already told. Jury instructions already told. It must be 35, 40, might be more. And then you have those that are being told before, after closing arguments or before closing arguments. Jury instructions that has to be told. As Sheila Reed says, even though they are tried together, they are each charged separately. Yeah. No, Ken. You do not get a virtual happy ending. But thank you. Thank you. All right. Other than that, what is upcoming on this channel? Well, there's still a lot of Young Thug trial material to cover for me. You have the Fonnie Willis debacle. I'm still skimming through the dockets about more dirt on Prosecutor Love. Friday panel show is me, Kat, and now I'm Empress Fox. Empress Fox is confirmed for Friday, and I have a maybe from Mr. Doug Weinstein. So that is what we have for Friday. And also, Friday is Halloween, so somewhat Halloween themed on Friday. Other than that, I'm doing some covering of the Delphi trial. Those are videos you really need to see, because Judge Gull in that trial makes both Glanville and Whitaker seems like epitome of fairness in comparison. So if you have nothing to watch, I suggest you watch the Delphi coverage, at least the last week of videos I made on it. The videos I made so far are including that a lab employee contaminated DNA evidence, that an investigator testified to the jury that he is a living lie detector, which is so stupid, and that the toolmark expert in that trial, in my opinion, faked evidence. So those are the 3 latest videos I made on that one. The main thing about that case is that it's not televised, because Judge Gull, the judge there, banned not only cameras in the courtroom, she banned all electronics, so they can't use their tabs to make notes. They have pen and paper. She won't release the audio from the trial until after the trial. So we have to rely on people in the courtroom and their notes. I'm not tech savvy. If you don't get a PayPal amount through, sadly I have no clue. I have no clue why that is so. You might want to try to use my email address. If you go to PayPal and you write in my email address instead, I'm posting it now in chat. So if you use that instead, might have better luck. I have no idea. Let's see here. Ken's counseling couch. Pro tip, there's a Chrome extension called YCS YouTube comment search that also lets you search the closed captions. You could go through each day and search for forget to find the instructions. Maybe. I don't know who's running the camera, but the Naughty Brunette says, if you're on an Apple device, they seem to make everything difficult. Yeah. Can't be Maurice behind the camera today. I don't know. I don't know if it's Maurice or not. But I do know once he became the camera guy after a few months, things improved. The first few months of this trial, audio wasn't that good. Well, it's not tip-top now. That is why I'm using boosters. I'm using one booster that boosts it 25%, and that is called, I believe it's called, what's it called? Enhancer for YouTube. And it is a Chrome add-on. And the other one I'm using is called Volume Master. So once in a while, if the sound is really horrible, I could have both on max, both maxed out, and it's still bad audio. Then I will turn myself down so you can enhance it or turn up the volume yourself. Yeah, more about the Delphi case against Richard Allen. There's no DNA of him on the crime scene. They have swabbed everything on that crime scene. Everything. No trace of his DNA. There are traces of unknown male DNA that the state claims are too weak to make conclusions from. That's interesting. His fingerprints are nowhere to be seen on the crime scene. They went through his entire house and car, because he still had the car now as he had back in 2017. No trace of the girl's DNA. They went through his internet history. Nothing. Not before, not after. So you might ask yourself, well, why is he there? Well, a few days after the murders in 2017, the public was asked by the investigators, please, if you were around there, please phone in and tell us what you saw, to get anything. So he called in. He said, well, I was there. I saw 3 girls, but mostly I was looking at my phone and I didn't see anything. And 5 years later, he was arrested because they found an unspent cartridge between the girls. And and according to the toolmark person, it matched his gun.
All right, I apologize for the interruption. Thanks for y'all's patience. Some of the co-defendants in the ongoing trial wanted to be out here, so they are out here now. And Mr. Harvey, are we ready with Mr. Nichols?
Yes.
All right.
Do you want him at the podium or do you want him here at seated?
I think at the podium, please. Thank you.
Okay, now we get to hear what the actual plea deal is.
Thank you.
Now let's have him at the podium because he's going to have to take an active part in this entry. All right.
Okay, sure.
Sergeant, can you swear him in, please?
Raise your right hand. So I firm testimony you give the truth, the whole truth, nothing but the truth.
Yes.
All right. State, spell your first and last name for the court, so now into the mic, please, sir.
Marvius Nichols, Quamarvious, last name Nichols, Nichols.
Did you
All
get
right.
that? Is that? Okay. Do you want to do it again? All right. Slow down. Your name. Spell it for this young lady right here.
Okay, my name is Marvius Nichols, first name Quamarvious, my last name Nichols, Nichols.
And Mr. Nichols, are you the same person referred to as Quamarvius Nichols on indictment 22 SC 183572?
Yes,
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
no,
Have you had the opportunity to sign this indictment with your attorney, Mr. Bruce Harvey?
yes,
How old are you?
29.
And how far did you go in school?
I got my GED.
I did not hear you.
I got my GED.
Are you able to read, write, and understand the English language?
Yes,
Do you understand that in this indictment, you were initially charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carries a sentence of 5 to 20 years. You were also charged with count 49 in this indictment, which is murder, which carries a sentence of life. You were charged with 2 counts of participation in criminal street gang activity, which was counts 50 and 51, which each carried a sentence of 5 to 20 years. You were initially charged with counts 53 and 65, possession of a firearm by a convicted felon under Code Section 16-11-133, which each carried a sentence of 15 years consecutive to count 1. And then you were also charged with count 54, which is possession of a firearm during the commission of a felony, which carried a sentence of 5 years consecutive to count 1. Do you understand that that is what you were initially charged with?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over and review the waiver of rights form with your attorney?
Yes.
And I'm going to hand this to your attorney. Did you sign this along with your attorney?
Yes.
Have you had enough time to speak with your attorney, Mr. Bruce Harvey, about all the facts and circumstances known to you regarding the charge in this indictment?
Yes.
Do you need any more time to discuss this man with your attorney?
No.
Are you satisfied with his counsel and representation?
Yes.
And I'd include in there the counsel and representation by Ms. Westmoreland and Mr. Garland as well. You had a team of attorneys.
That's correct.
All right.
And they are all attorneys of record and have participated in this particular proceeding and negotiations leading up to this proceeding.
Thank you.
Do you waive formal reading of the indictment?
Yes.
Yes.
Do you waive any and all defects with respect to the indictment?
Yes.
And to your knowledge, have you been arrested on all the charges in this indictment?
Yes.
And Mr. Harvey, the state is unaware of any outstanding warrants related to these charges. Do you know of any outstanding warrants that are related to these charges?
Not related to those charges.
Have you been advised of the minimum and maximum sentence for each charge that you are pleading to?
Yes.
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court as to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, a sentence of 20 years to serve 7 years in custody, balanced on probation?
Yes.
Do you understand that as a part of the negotiated agreement, the state will null, or dismiss count 49, which is the murder count, count 50, 51, which are the gang activity counts, count 53, possession of a firearm by a convicted felon, count 54, possession of a firearm during the commission of a felony, and count 65, possession of a firearm by a convicted felon. Do you understand that is the negotiated agreement?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum on each charge and can run those charges consecutively or one after the other?
Yes.
So,
Well, there's only one charge that
so
a guilty plea is
I
being
was-
entered into. So
under my breath to that.
there's no other sentence to run anything consecutively with
Right.
regard to this plea. You understand that?
Yes.
Okay.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
Do you understand you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or Board of Partisan Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you'll be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? After each right, I'll ask you to say yes or no if you understand. The right to a trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist with counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charges against you proved beyond a reasonable doubt,
Yes.
the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charge against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
That can challenge anything about the constitutionality of the plea. It's not limited to voluntariness, understand?
Yes.
And Your Honor, if this case were to.
Hang on just a second. You also have, so 4 years for that, to file a direct appeal. You have 30 days from the date of sentencing, which is going to be today. And you have until the end of this term of court to file a motion seeking to withdraw your guilty plea. That doesn't mean anything like that would be granted. You would have to establish facts that would warrant that. But that's just the time period is until the end of this term of court. Do you understand those as well?
Yes.
All right.
Your Honor, if this case were to continue with trial, Your Honor, the state would expect, as to this defendant, the state would expect to show that what has already come into evidence that on July 3rd, 2017, as well as October 23rd, 2018, that this defendant is an associate of the enterprise of YSL, also known as Young Slime Life, and that he conspired to associate together with others for the common purpose of illegally obtaining money and property through a pattern of racketeering activity and conducting and participating in the enterprise through a pattern of racketeering activity. In furtherance of the conspiracy, this defendant engaged in the activities below. He engaged in activities that assisted with preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity to include murder, assault, and threats of violence. That this defendant preserved, protect, and enhance the reputation, power, and territory of the enterprise by the posting of messages, images, appearance in videos, and songs demonstrating allegiance to the enterprise and a willingness to engage in violence on its behalf, and to obtain money, weapons, and other property through acts of racketeering activity, including the unlawful sale and distribution of drugs. Your Honor, evidence has come in during this trial that on July 3rd, 2017, Mr. Nichols was located at 2612 Steel Avenue, which is in the Cleveland Avenue sector of the city. Your Honor, he was found inside of a vehicle. When that vehicle was searched, Your Honor, this was in October of 2018, they found marijuana as well as sandwich baggies that would be used to package drugs. and there are also guns found inside of that vehicle. Also in July of 2017, this defendant was stopped during a traffic stop in the Cascade area, Your Honor. After being stopped, Your Honor, there was a consensual search of the vehicle that yielded powder and MDMA, Xanax, as well as a loaded gun inside of that vehicle. Additionally, Your Honor, in July of 2019, Mr. Nichols was featured in a video with another YSL member, Shannon Stillwell, and Woody Lee. In that video, it was entitled Slap Talk. And in that video, co-conspirator Shannon Stillwell, while performing, makes such quotes as, "Me and my slimes are above the law." We know from the evidence that slimes is one of the terminology used by members of YSL.
Oh, they put in a lot in that video.
This enterprise. And then last but certainly not least, Your Honor,
They are getting
in
evidence
March of
confirmed
2022,
via Mr. Nichols.
Mr. Nichols was found in surveillance video at a gas station at Windsor Street and Fulton Street here in Atlanta, Georgia. This was on March 14, 2022, during what the state would believe to show an onset of a gang war that really started in 2015 with the death of Donovan Thomas, that carried on into 2022. In February of 2022, a rival gang member by the name of Rayshawn Bennett, also known as YFN Lucci, was stabbed at the Fulton County Jail in February of 2022. Information about that stabbing was made public at the early part of March 2022, around March 3rd of 2022. Once that information was released to the public, there was an onset of retaliatory activity that occurred between March 3rd, 2022 and March 16th of 2022. That includes a March 11th homicide of YSL associates Christian McMiller and Darius Ford. It also then included a retaliatory shooting of a YFN associate, and then ultimately it led to a murder of Shamel Drinks, who we believe is a YFN associate. This murder occurred again on March 14, 2022. Mr. Nichols is seen on surveillance video at that BP gas station, as I just referenced earlier. He was at the gas station with YSL co-conspirator Shannon Stillwell. Mr. Stillwell was driving an Audi vehicle. Mr. Nichols came to that gas station in a Ford Fusion vehicle. You see both of them on camera together. While they are at that gas station, Shamel Drinks approaches that gas station as well. I think unbeknownst to Mr. Drinks, Mr. Stillwell was still in his vehicle, which is the Audi. At some point in time, Mr. Nichols got to his vehicle, the Ford Fusion. Once Mr. Drinks finished his business or finished handling business at that gas station, we know that there is a phone call between occupants of the car that Mr. Stillwell was in and occupants of the car that Mr. Nichols was in. That communication was to the effect that you need to get on FaceTime. As soon as that conversation ensues, we see Mr.
Why is all
Drinks
of this in
leave
there?
the gas station in his vehicle, and both the car that Mr. Stillwell is driving, as well as the car that Mr. Nichols is driving, both follow out of the gas station, following behind Mr. Drinks.
This is bad for Mr.
Mr. Drinks
Stillwell.
proceeds down the
Really
street to
bad.
the light at Windsor, which is right by I-20 in Windsor. Mr. Drinks is in the far left lane. The car involving with Mr. Stillwell pulls up to the middle lane, and Mr. Nichols' vehicle pulls up to the far right lane. This is all captured on surveillance video and surveillance camera. They are at the light for a moment. Then we see both this car with Mr. Stillwell as well as the car with Mr. Nichols drive through a red light, leaving the car with Mr. Drinks sitting at that light. About 30 minutes later, a Good Samaritan sees that car still sitting there, approaches the vehicle, and Mr. Drinks is now deceased inside of that vehicle. We had know through LPR readers that both Mr. Stillwell's vehicle and the car involving Mr. Nichols drive in the direction of 20 westbound and follow in tandem. 2 days later, when after the case is investigated and arrest warrants are taken out. On March 17th, 3 days later, Mr. Nichols is found with Mr. Stillwell at a Chick-fil-A gas station, Chick-fil-A restaurant. There is a chase, I won't call it a high-speed chase, but there is a chase through the city of East Point, and eventually Mr. Nichols as well as Mr. Stillwell are both apprehended after arrest warrants were ultimately taken out for the murder of Mr. Drinks, Your Honor. Given where we are in the case, Your Honor, we know that Mr. Nichols, we do not believe Mr. Nichols was in the vehicle in which the shooting occurred, but he was in this other vehicle. The state has made a decision to move forward with this recommendation for the RICO count, Your Honor, for count 1.
Mr. Harvey, are y'all acknowledging a factual basis to the count 1, the RICO count?
Okay, we are acknowledging a factual basis. There has already been evidence with regard to the July 3rd, 2017 drug event, the October 23rd, 2018 drug event. We categorically deny and contest any use of violence by Mr. Nichols. We don't agree to that underlying factual basis. We believe those two predicate acts that were committed by Mr. Nichols without any question are sufficient to meet the elements of the offense. The offense to which he's pleaded to, which is a RICO conspiracy. A RICO conspiracy requires proof that the defendant either conspire with another person to violate one of the substantive provisions of RICO, and that would be drug offenses, or personally endeavor, I believe that's what the language of the statute says, to violate one of the substantive provisions.
Well, that's what the language of the statute says, but
Yes.
he is indicted in this indictment with conspiring, not with endeavoring.
That's correct. So we're talking about a conspiracy. We acknowledge the two events that he participated in. We categorically deny any other allegations other than those two events that are sufficient for a factual basis. We categorically deny that we participated in any way in the unfortunate death of Mr. Drinks. We categorically deny any other charges to which we are, substantive charges to which we are not entering a plea, and that includes gang charges. This is a plea solely to a conspiracy to violate the RICO Act. So but yes, we acknowledge a factual basis to that extent, Your Honor.
Understood. All right, thank you.
Yeah, so the prosecution tried to enter more into this plea, to my understanding, and I'm sure Mr. Harvey does not make this mistake. Whatever she said, in addition to what's actually on the paper, they do not, especially when it regards the murder charges, because the murder charge was dropped. So, another attempt from the prosecution. Another one.
We just have one additional thing to say.
Go ahead.
The factual basis regarding the nature of YSL is that the evidence has shown and will continue to show that Mr. Nichols conspired with others to participate in Young Slime Life through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature of and asserting
the jury
dominance
is not
of
present
Young
for
Slime Life,
this.
also known as YSL. And that concludes our factual
And
basis.
again, once again, we categorically deny those representations. And again, the only thing that is necessary to meet the factual evidence of a 1614-4C is proof that the defendant conspire with another person to violate one of the substantive provisions of RICO, and that is subsumed by the drug offenses that have already been proven in this case and to which Mr. Nichols has previously pled.
All right, thank you. Understood.
And Your Honor, may I approach with the waiver of rights form again?
Yes.
So, in my opinion, the state tried to bite more. They tried to make a bigger bite than
All
necessary.
right. Mr. Harvey, have you reviewed with Mr. Nichols this plea of guilty and waiver of rights form, which the two of you have both signed?
I have, Judge, in
All
each
right.
individual provision in that plea colloquy has been acknowledged and gone over personally with Mr. Nichols.
All right. And Mr. Nichols, have you had sufficient time to consider this guilty plea that has been negotiated between the state and your attorneys, and to discuss anything you wanted to about that with your attorneys?
Yes.
All right. And you understand, I hope, I'm going to ask you, that it is your decision ultimately, obviously with the advice of your attorneys, but it's ultimately up to you individually to decide whether you want to enter this guilty plea or not. Do you understand that?
Yes.
All right. And you do want to enter this guilty plea?
Yes.
All right. And Mr. Harvey, have you advised Mr. Nichols of the alternatives if he does not ultimately go through with this guilty plea, and the potential benefits and drawbacks of all of the other options?
Yes,
All right.
very thoroughly, Judge.
All right. All right, Mr. Harvey, is there anything that the defense wants to add to the record?
Judge, other than the statement with regard to the underlying factual basis, I would point out for the court that when Mr. Nichols filled out his form, it says 29 plus. He is a birthday boy in a couple of days and he will be 30. And at 30 years of age, he has a wife. He has got a 13-year-old daughter. He's got a 10-year-old daughter and an 8-year-old son. His wife and sister, I believe, are here in the courtroom to support him. He, Mr. Nichols, was born and raised in Atlanta. And, you know, we're at this point, before I have even given my opening statement in this case,
Yes, sir.
I do want the court to know that Mr. Nichols' mother died in prison. His father was shot by the Atlanta police when he was 4 years old. And he was raised by friends and family in the Atlanta area. So he has come to this point in his life from a very humble beginning. And he has sought the support of friends in this courtroom and others in this courtroom. He is an intelligent young man who I believe has a future. Every day we do a word of the day. We put a new word into a sentence. And I think this is in his best interest. I know that there is, and I know this plea is negotiated, but it's a long downside from 7 to 20. So the courts will have jurisdiction over him for a period of time. So I asked the court, given who this young man is, and given our categorical denial of some of the factual basis, to accept the plea and sentence Mr. Nichols accordingly.
Mr. Nichols, is there anything that you want to say?
No, ma'am.
All right. All right, I find there to be a factual basis for the guilty plea to the RICO count one of the indictment, that being a conspiracy to acquire control or interest in money and personal property through a pattern of racketeering activity. And that is the only count that guilty plea is being entered for. The remaining counts of this indictment as against Mr. Nichols are being null pros by the state as a part of this indictment. I find, having heard the evidence up to the point of trial right now, that there is evidence of at least one overt act in furtherance of the conspiracy. And that there is evidence that would fall within the required statute of limitations to establish this RICO conspiracy count. One of the things that we as judges are instructed by our Uniform Superior Court rules to do when we are considering whether to accept a guilty plea and whether to accept a negotiated sentence, and this is a negotiated sentence in this case, is to take into account whether giving leniency in sentencing is going to aid in ensuring promptness and certainty, or at least more promptness and more certainty with regard to corrective measures, whether the defendant, and in this case, the defendant has acknowledged guilt and is accepting responsibility for his guilt of the RICO count, and whether accepting the plea will aid in avoiding further delays, not just with regard to this case, but with regard to the entirety of our system here in Fulton County. And this plea does go towards doing all of those things. I am going to accept the plea as negotiated and sentence in accord with the negotiated recommendation. As I said before, find there to be a factual basis for count one of the plea. I find the plea to have been freely, knowingly, intelligently, and voluntarily entered into by Mr. Nichols with an understanding of the consequences of doing that. And the sentence on count one is the sentence that has been negotiated of 20 years to serve 7, with the balance of those years to be served on probation. And that, I don't know if there are any special conditions attached to this that y'all have talked about at all.
There are no negotiated special conditions in those, so there are none as far as I'm concerned.
All right. No. Okay.
He doesn't
So
have to
with
testify,
regard to the time that
No
you were on
special condition
probation,
of testifying.
you need to stay out of all kinds of criminal trouble. Make this a birthday present to yourself and to your children and to your wife and family, that you will leave from here today and leave whatever you used to do behind you, and take the next few years. You know, you're going to have some years that are still to be served on this. You'll have credit for the time you've already served, but you're still going to be facing some incarceration time. But after that, you are going to be out, and you, I believe, Mr. Harvey is correct, can be a productive member of society. And this is an opportunity for you to do that, and for you to put your past behind you, the bad parts of it, and continue and make your children proud of you, and set a good example for them, an example that I guess, unfortunately, you were not lucky enough to have throughout the entirety of your childhood with your parents. I'm sorry about that, but you can be the kind of parent that you ought to be to your children. So I am going to impose that sentence, and I am going to wish you luck and good fortune as you go forth from here. So I think that unless there's anything else from either party, that will conclude these proceedings, and y'all can go ahead and take him into custody. Thank you.
Thank you, Judge.
And Ms. Taylor will make this an exhibit to the plea. Thank you. All right, we are adjourned for the day. Oh, okay. I'm gonna do the wrong.
Yeah, he will be home before Monk Tonk. Had to be, so he goes free. He only has probation? No. Okay, that was end of... this part, folks, this is only one plea deal. The trial is not over. The trial is not over. I would assume that negotiations will continue with the people who are still interested. I have no idea how they... Yeah, I thought, yes, Philly, I thought also it was 2 plea deals. Apparently it was just this one. So Mr. Nichols accepted a plea deal of 20 years, 7 of those in prison, minus the time he has been in jail, which is almost 2.5 years. Well, it is, almost 2.5 years, which leaves 4.5 years, of which he might serve 3 to 3.5. And then he is out on probation for the remainder. So, but no, the trial is not over. The trial is not over. This is just one of the plea deals. I have no idea how the judge will handle this with the jury when Mr. Nichols is gone. Now, what was good here, because we all heard the prosecution on and on and on what they believe was within the factual acknowledgement, and Mr. Harvey was there to put a stop to it, saying the only 2 things Mr. Nichols is pleading guilty to are the 2 drug distribution charges. Only those 2. The rest, vehemently deny. Vehemently. So I thought first, oh, this is bad for Mr. Stilwell. No. Because now Mr. Nichols does no special conditions, means he does not have to testify. Mr. Nichols doesn't have to testify, which means that the prosecution still has to prove all the others against Mr. Stilwell. But now they can't bring in Mr. Nichols. But how this affects the rest of the trial, I have no idea. How can the judge tell the jury that there is a plea deal and you have to ignore those parts? How? Without it being prejudicial towards the rest of the defendants, that one person on this trial took a plea deal after 11 months of trial. How? I have no idea. I have no idea. Eric Rose says, anyone saying 20-year probation is a good thing? Obviously, never been on probation. Eric, Mr. Nichols was facing life, probably without parole. He would die in prison. He would see from a distance, see his kids grow older. He would not be able to attend their prom or see them for the prom, see them graduate, see them get married. He might get photos of it, but never be there. That was what he was facing. With that on the horizon, spending another 3.5 years in prison and then go on probation, not that bad of a deal, even though I believe that 20-year probation is a scam. It's a big scam. Now, the prosecution giving up the murder charge just for the RICO tells us all has nothing to do with the murders. This trial has nothing to do with the murders. This trial is about the RICO and to get Mr. Williams, and that alone. Only that. Now, I don't know if there will be other hearings or if they are back on trial tomorrow morning. I have no idea. No idea. But as it seems, this is the only one we know of so far. Maybe we will hear another one tomorrow. Have no idea. I wish I knew, but I don't. I wish I knew more and could. Yeah. But the main thing to take away from this, again, is how this prosecution still wants to cheat. They made claims to the court that in his guilty plea of the RICO, he acknowledged everything. They are just not charging him anymore for the murder, which is bullcrap. And Mr. Nichols was on top, or Mr. Harvey was on top of it and said, "Nuh-uh, we're only pleading guilty to 2 things, 2 drug charges. That's it. The rest, vehemently denying. Vehemently." And yeah, so this will be interesting to see how this judge is going to solve the rest of the trial when Mr. Nichols all of a sudden is gone. She has to address it to the jury. She has to. But how can she do that without it being extremely prejudicial? I don't know. But that is what I had for you today. That is what I had for you today. Let's see if I can throw you over to... Let's see. Oh, of course, Catnot Williams. Yeah, I'm going to send you over to Catnot Williams for further discussion. Thank you all for being here. Thank you for super chats. Thank you. Thank you for allowing me to do this. Thank you for allowing me to try to translate this for you. Even though I make mistakes sometimes, you are excellent in bringing me into bringing me in again. All right. Tomorrow, I assume we will find out eventually. But until tomorrow, hug your family, folks. Unless you're... okay, not yet. Snivels! Gifted 10 memberships at the very end. Thank you. Went to Sheila Reed, Gwendolyn, Samantha Yo, Sack, Daryl Field Sr., Lisa Wilson, Proverbial Fly, Jenny, Kat, and Nisha. Congratulations, folks. And thank you, Snivels, for your support of this channel. All right, now, hug your family. Unless your family is crap. If they are, screw them and give your love to the people who deserve it. And I will see you back here tomorrow. All right. Bye-bye.
Defending the voiceless, the wrongly accused, facing the foe whose motives are abused. In the courtroom battlefield, they'll stand tall, unveiling corruption, they'll conquer it all. Against the corrupt prosecutors' wrath, with words like weapons cutting like a path, challenging the system that's filled with lies, seeking truth with justice in their